the United States Supreme Court in Mission Product Holdings, Inc. versus Tempnology, LLC, and its implications for franchisors and other trademark owners. This decision resolved a split among the Federal Circuit Courts of Appeals on the treatment of active trademark licenses when the trademark owner files for bankruptcy. My name is Sheldon Klein. I am a principal at Gray Plant Moody, resident in our Washington office, and a senior member of our firm's intellectual property, technology, and privacy practice group. Trademark law is a primary focus of my practice. I am also president of the American Intellectual Property Law Association, which filed an amicus brief that was cited in the concurring opinion of the case we are discussing. With me today are my fellow Gray Plant Moody senior partners, Jim Wall and Phil Bull, who will introduce themselves shortly. A few technical details before we get started. We've muted your audio, so don't worry about making any noise on your end. We welcome your questions. You can use the chat feature on your screen to submit questions at any time. The presenters are the only ones who will see your questions. We will address them at the end of the presentation, time permitting, or we'll follow up with you directly if time runs out. In the next day or two, our firm will send you a follow-up email which will include our slide deck and a link to our website, where a recording of this webinar will be posted. We encourage you to share it with others in your organization. Jim?
Thank you, Sheldon. My name is Jim Wall. I'm a principal in the Minneapolis office of Gray Plant Moody, and I work in the franchise and distribution practice group where I work on franchisor, transactional, and registration and disclosure matters, as well as corporate matters for franchisors. I also do a fair amount of trademark registration and protection work.
And my name is Phil Bull. I'm a shareholder in the Commercial Financial Services Group, practicing primarily in the area of commercial reorganization and bankruptcy cases. A significant part of my practice is representing franchisors in franchisee bankruptcy cases around the U.S. So I will begin the discussion this morning by trying to establish the context for which we will present our program and the analysis of the recent Supreme Court decision. The Bankruptcy Code includes a special set of rules for dealing with what are referred to as executory contracts. Under bankruptcy law, an executory contract is a contract under which performance remains due to some extent from both parties to the contract. Fundamentally, this definition is intended to capture contracts that are both an asset and a liability to the parties to the contract. Both trademark licenses and franchise agreements are executory contracts for bankruptcy purposes. With respect to the licensor or franchisor, the asset under the contract is the royalty stream typically that it will be receiving, whereas the liability feature of the contract is the obligation to support the trademark. From the perspective of the licensee, the asset is its access to the trademark and to the support that it will receive, and its liability, of course, is to pay the royalty required under the license. When a party to an executory contract files bankruptcy, all of its rights and obligations under that executory contract are transferred to the bankruptcy estate by operation of the Federal Bankruptcy Code. That transfer occurs regardless of any restrictions on transfer that might exist under the contract itself. When a party to an executory contract files a commercial Chapter 11 bankruptcy case, its management team remains in control of the company and continues to operate the business under the protection of the bankruptcy court. Under bankruptcy parlance, the management team is referred to as the debtor in possession, or DIP. For the purposes of these slides, we've shortened that just to debtor, but that is what we're referring to. The remainder of these slides all assume that the party that has filed bankruptcy, in our case the trademark owner and licensor, has filed a Chapter 11 case as opposed to one of the other types of bankruptcy cases. Once a debtor files a Chapter 11 case, the debtor has three different options for dealing with each of its executory contracts. And in each case, the option that it selects with respect to a particular executory contract must ultimately be approved by the bankruptcy court. The first of those options is assumption of the executory contract. This choice has the effect of restoring the contract to full force and effect as between the debtor and the non-debtor counterparty to the contract. The second option that the debtor has is to assume the executory contract and assign it to a third-party purchaser. The result of this alternative is that the contract again is placed in full force and effect, but as between the assignee of the debtor and the counterparty to the contract. We will not further discuss either of those two options in this presentation because neither of those options is the subject of the mission product decision that we're here to discuss today. The third option identified on the slide is what is called rejection of the executory contract. The meaning and consequences of rejection of an executory contract by a debtor has generated a large amount of conflictory case law and much scholarly debate, literally for decades, in the bankruptcy world. And this debate covers rejection of any type of executory contract, not just intellectual property licenses. Historically, the courts have analyzed the consequences of rejection under two largely incompatible theories. The first theory is referred to as rejection as rescission. Under this theory, the courts conclude that rejection essentially terminates or vaporizes the underlying executory contract that has been rejected. As a result of this analysis, the terms of the contract are no longer enforceable by or against either the debtor or the counterparty. Again, that's rejection as rescission theory. The second theory is labeled rejection as breach. Under this theory, rejection is treated as a breach of the executory contract by the debtor. But the contract itself is not rescinded, and the non-debtor counterparty's rights and obligations under the rejected contract are determined under applicable non-bankruptcy law. Let's now turn to how these two theories are applied to the rejection of trademark licenses or franchise agreements, and more specifically, to trademark licenses or franchise agreements under which the debtor is the trademark owner and licensor. And that debtor then rejects the trademark license or franchise agreement with the approval of the bankruptcy court. The First Circuit decision, which is referred to here as Tempnology, LLC, but is the decision from which the appeal to the Supreme Court was taken, adopted the rejection as rescission theory. And applying that theory to the trademark license, concluded that the non-debtor licensee lost all rights to use the trademark post-rejection. The First Circuit's analysis in that decision is based upon a much earlier Fourth Circuit decision, the Lubrizol Enterprises decision cited on the slide, under which the Fourth Circuit adopted the same rejection as rescission approach and concluded that an intellectual property license that had been rejected by the debtor licensor resulted in the licensee losing all of its rights to use that intellectual property. In contrast, courts that have applied the rejection as breach theory to the licensor's rejection of a trademark license have come to the opposite conclusion regarding the licensee's ongoing rights and obligations. Those courts hold that the non-debtor licensee does not lose its rights to the trademark as a result simply of the licensor's rejection. Those courts treat rejection as nothing more than a breach by the licensor, and conclude that outside of bankruptcy, the licensor's breach would not result in the deprivation of the licensee's rights to use the underlying trademark. These courts base their analysis on Bankruptcy Code Section 365G, which basically states that the rejection of an executory contract constitutes, number one, a breach of that contract that is deemed to have occurred immediately prior to the filing of the bankruptcy case. That provision, by the way, Section 365G, applies to all types of executory contracts, not just intellectual property licenses. So that brings us to the Supreme Court's Mission Product Holdings decision. The First Circuit decision in the Mission Product case created the circuit split with the Seventh Circuit's Sunbeam decision that resulted in the appeal to the Supreme Court. In its decision, the Supreme Court came down solidly in favor of the rejection as breach theory and equally solidly rejected the rejection as rescission theory proposed by the First Circuit. What the Supreme Court said is quoted in the first bullet point, which says rejection of a contract, any contract, in bankruptcy operates not as a rescission, but as a breach. So clearly the Supreme Court was looking well beyond just intellectual property licenses and certainly just trademark licenses with that statement. Then, after holding that rejection is a breach of the contract, the Supreme Court instructed that one looks to applicable non-bankruptcy law to determine the licensee's rights and obligations under that license thereafter. Under the rejection as breach theory, the Supreme Court concluded that the debtor licensor may cease performing its obligations under the license, that's what rejection accomplishes, but that the debtor cannot rescind the license, and the licensee may continue to use the trademark, and this is important, in accordance with the terms of the license agreement for the remaining term of the license. With that background information, I'd now like to turn the podium over to my colleague, Sheldon Klein.
Thank you, Phil. So, how can a debtor licensor that rejects a trademark license avoid having its trademark weakened or, worst case scenario, destroyed when the licensee elects to continue using the mark? This is especially concerning since in many cases the bankrupt trademark owner will lack the resources to police use of the mark with the same rigor as it might have done pre-bankruptcy. Also, what are the continuing obligations of both parties? For the answer, according to the court, we should look to applicable non-bankruptcy law, as the court instructed us. Specifically, we consult trademark law and contract law. First of all, the licensee remains contractually obligated to maintain the nature and quality of the goods or services under the core terms of all but the most poorly drafted trademark licenses. This is so even if the licensor does not actively police the mark during bankruptcy. if the licensee begins to sell goods or services that are of materially reduced quality, that's a breach by the licensee, which, if not cured, would ordinarily trigger the right of the licensor to terminate the license. This right should not be impacted by the mission product decision. Once the license is terminated, all use of the mark would have to cease. Of course, it's preferable for a licensor in bankruptcy to continue to perform at least some minimal level act of quality control. A licensor that ceases to exercise any quality control does risk weakening its mark. In extreme cases, allowing unfettered use of a mark can result in an abandonment of trademark rights. But a trademark owner's quality control can be minimal and still be sufficient to preserve rights. It can take the form of a cursory periodic examination of product specimens or of premises from which services are offered, or even a 2-minute review of the licensee's website. Just because a licensor does not perform all of the quality control that the license entitles it to perform does not mean that the mark is abandoned or even materially weakened. The law would weigh heavily against working a forfeiture of a debtor's valuable intellectual property. Maintenance of quality level is such a fundamental component of trademark licensing that in licensing situations governed by poorly drafted or bare-bones licenses, which contain little or no explicit quality control provisions, courts have read the requirement into the agreement. The same is true of licenses that are completely oral, which have been held enforceable in certain circumstances. Courts have held that the party's conduct alone can provide evidence that a license exists and that quality control is occurring. So in a situation involving a rejected trademark license, if the licensee elects to continue using the mark, it remains obligated to adhere to quality standards set out or implied in the license. This is a requirement of both contract law and trademark law. The trademark licensee might assert that, in view of the debtor's rejection of the license or lax quality control, it, rather than the debtor, now owns the trademark. But ordinarily, that claim would not be recognized. Most trademark licenses contain a provision whereby the licensee recognizes and agrees never to challenge the validity of the mark and the licensor's ownership of the mark. This provision survives rejection of the license. Moreover, even in the absence of such a provision, the doctrine of licensee estoppel would normally dictate that a licensee is estopped from challenging the mark or asserting ownership. Courts have held that this trademark doctrine is implied by virtue of the licensee's agreement to the license. Justice Sotomayor gives us an instructive gloss on the court's decision in the Mission Product case in her concurring opinion. She states that by treating rejection of a trademark license as a breach rather than rescission, the court does not decide that every trademark licensee has the unfettered right to continue using licensed marks post-rejection. Rather, the baseline inquiry remains whether the licensee's rights would survive the breach under applicable non-bankruptcy law. She adds that special terms in a licensing contract or state law could bear on that question in individual cases. So, operation of law or particular contract terms could potentially lead a bankruptcy court to limit licensee rights post-rejection. Some special terms typically found in a trademark license, especially a license that is encompassed in a franchise agreement, include detailed product or service specifications, geographical limitations, the obligation to pay royalties, and the obligation to adhere to a detailed style guide for display of the mark. Failure to adhere to any of these obligations could constitute a breach by the licensee and separately entitle the debtor to terminate the license, regardless of whether the debtor has rejected the license. Most licenses provide that the licensee must adhere to all local, state, and federal laws. So use of a mark in connection with the operation of a business that is not properly licensed such as home health care providers, restaurants, pet groomers, home improvement contractors, and medical marijuana dispensaries, can trigger termination. Use of a mark in furtherance of a criminal enterprise, such as selling counterfeit goods, would also justify termination. An important aspect of trademark law, and especially the quality control requirement, involves a strong public interest and consumer protective component of the law. As the Eighth Circuit has stated, the purpose of the quality control requirement is to prevent the public deception that would ensue from varying quality standards under the mark. In order to protect the public, as well as the debtor trademark owner, we would expect the bankruptcy court to apply non-bankruptcy law, in this case, trademark and contract law, and uphold termination of a trademark license, regardless of whether it was initially rejected by the debtor, and enjoin continued use of the mark if the licensee breaches the license by failing to maintain quality. For example, in one case, a court upheld an injunction against the sale of stale foods, even though the contract did not explicitly prohibit its sale. There is a public interest in avoiding the deceptive sale of unwanted goods sold under the brand name, which carries with it a particular expectation of quality level. Potential injury to the public can occur by purchasing a sub-quality consumable product, such as food and beverages, or a dangerous product, such as counterfeit drugs or machine parts, or flammable clothing. These are all situations that would constitute a material breach and provide grounds for the debtor to seek an injunction against further use of the mark, notwithstanding the Supreme Court's ruling on rejection as breach rather than rescission. Jim?
Thanks, Sheldon. Thanks, Phil, for the kind of setting the table and the more general context of bankruptcy and licensing in general. Now we'll shift our focus to what happens in cases where a franchisor is the debtor in bankruptcy. Based on our experience, it's probably more typical that when a franchise system is in a bankruptcy proceeding, a reorganization proceeding, the motivating factors are not necessarily the franchise agreements, but it's more typical that there's a restructuring of lender arrangements where there may be underperforming corporate stores that are being dealt with. And in those cases, typically what's going to happen is that there would be an assignment or, an assumption or assignment and assumption of the franchise agreements. There may, in many cases, not be any change at all at the franchisor level because as a result of the bankruptcy proceedings, and so the franchise agreements would just continue in effect unchanged, or they may be, if there's a restructuring that creates a new franchisor entity or a sale, then the agreements would be assumed and then assigned. There are, however, situations where the restructuring of franchise agreement terms is one of the motivating factors for the bankruptcy. And in that case, the franchisor is going to look at the option of rejecting some or all of its franchise agreements, and that's the situation where the mission product decision has really changed the ground rules and analysis for what the franchisor needs to consider and the franchisee's options and rights and obligations if that is done. So if rejection of the franchise agreements is one of the objectives of the bankruptcy, then generally it's going to be the motivating factor there will be for the franchisor to reduce its expenses of performing its obligations that are required under the franchise agreement. Generally speaking, they're going to want to reduce the level of support or training that they provide. Those types of obligations generally involve ongoing training and support of franchisee operations, review and development of new proprietary products that are specific to the franchise system, development of advertising, new promotional methods, those sorts of things are obligations that the franchisor typically has under the franchise agreement, and so rejection of the franchise contract would work a breach of those and relieve the franchisor of performing those obligations. There may also be situations where the franchisor is seeking to modify the royalty structure as a part of the overall rejection strategy, and that's probably where the mission product holding comes most into play. Because the rejection of the franchise agreement is now treated as a breach by the licensor/franchisor, the franchisor that's considering rejecting franchise agreements has to keep in mind that franchisees' rights and obligations are not going to be impacted by the rejection. So, for example, we've listed various typical franchise agreement provisions that are rights and obligations of the franchisee, and the franchisor's rejection of the contract is not going to impact those rights and obligations of the franchisee. As Phil said earlier on, the agreement on the licensee side essentially remains in effect. If the franchisor takes the route of rejecting one or more of the franchise agreements, then those franchisees who are impacted by that rejection have an election to make on their side. They have the option to either treat the rejection of the franchise agreement as a termination of the franchise agreement, or they can treat it as a breach by the franchisor, in which case they retain the rights that existed immediately prior to the bankruptcy filing under the franchise agreement. So a franchisor looking at the option of rejecting franchise agreements has to understand that the franchisee is going to have this option, and this effectively remains unchanged by the mission product holding. This election on the part of the franchisee or licensee existed under prior case law. In a situation where the franchisee elects to treat a rejected franchise agreement as terminated, that means that its rights under the contract are going to cease to be in effect. So it will, if it treats the contract as terminated, be prohibited from using the franchisor's trademarks, trade secrets, manuals, and other intellectual property. It will effectively have to change the way that it operates its business. The confidentiality and non-compete provisions of the franchise agreement are not going to be invalidated by the franchisor's rejection of the contract or by the franchisee's election to treat the franchise agreement as terminated. Those types of provisions are going to be analyzed under applicable state law and the terms of the agreement. So if you've got a situation where a franchisee has opted to treat the franchise agreement as terminated, it may or may not be able to continue operation at its location under a different name using a similar type of format for the business. Whether that covenant not to compete is enforceable is going to be analyzed under the terms of the franchise agreement and applicable state law. On the other hand, if the franchisee elects to treat rejection as a breach by the franchisor, then so long as the franchisee is in compliance with its obligations under the franchise agreement, it's going to continue to enjoy the rights and obligations that existed prior to the filing of the bankruptcy case. In other words, it's going to have the right to continue to operate under the brand and business systems that the franchisor has licensed under the agreement, It's going to have an obligation to continue to pay royalties. Its territorial rights will remain in effect. So it will have, if it has an exclusive territory, for example, under the franchise contract, that's going to remain in effect. Other provisions of the franchise agreement are going to remain effective as well. Conditions on assignment, for example, will remain in effect. It won't have the right to sell its business without, in this case, the debtor in possession consenting to that transfer. And as Sheldon described, under license agreement terms in general, the franchisee will be obligated to continue to abide by the quality control and standards provisions of the franchise agreement, and if it fails to do that, it's potentially subject to having the agreement terminated by the franchisor. Post-termination obligations will be enforceable to the extent they are under the terms of the contract and applicable state law. The one additional thing that will come into play is that the franchisee in this case will have an unsecured money damages claim against the franchisor for any damages that it has sustained as a result of the implied breach of the contract as of the immediately prior to the filing that's worked by way of the rejection of the franchise agreement. Sheldon mentioned Justice Sotomayor's concurrence in which she made some statements about the rejection of the consequences of the rejection of the agreement being altered through the terms of the franchise agreement. And that sort of leads to the question of whether the franchisor might, by terms of the franchise agreement, somehow alter the effect of the mission product decision in terms of more or less going back to a rejection equals rescission type of theory. We've looked at that question and think that really what she was talking about there is terms of the contract that would impact the franchisees or licensees' rights as a result of acts or omissions by the franchisee, as opposed to contract terms that the franchisor might try to put into the agreement that would alter the result. We think it's unlikely that any provisions in the agreement that try to invoke a rejection as rescission type of theory would likely be found unenforceable. The decision and Justice Sotomayor's concurrence in particular also talked about the impact of state law on the issue of the franchisee or licensee's continuing rights. And here we would need to look at the states that have franchise relationship laws, and particularly good cause for termination. So if a franchisor were trying to use some breach by the franchisee or other terms of the franchise agreement as a ground for terminating the franchise agreement in the bankruptcy proceeding, the franchisor would need to be cognizant of good cause for termination limitations on its right to terminate and other types of state laws, and would also have to take into effect in certain states that there are inventory repurchase requirements that come into effect in the event a franchise agreement is terminated. So up to this point, we've been talking about what happens, the impact of the mission product decision on a typical single unit franchise agreement and how that plays out in terms of the parties' rights and obligations under the contract if there's a rejection. There are also other types of agreements that are typically used in franchise systems, area representatives and multi-unit development agreements being probably the most common examples of those in U.S. franchising. Under an area representative agreement, the franchisor contractually assigns some of its obligations under the franchise agreement to an area representative. These are typically parties that operate one or more units of the franchise system, and in addition to those operations, they take on the obligation to recruit new franchisees, and once they're signed up by the franchisor, help them to find locations, provide pre-opening support and training, and after opening, they provide post-opening operational support and assistance. These types of agreements are probably impacted by the mission product holding because trademark use is generally permitted. The area representative is typically appointed as an agent of the franchisor to provide these services to prospective and new franchisees as well as existing franchisees. And so we have to look at it in terms of what the impact of the mission product holding would be on this type of agreement. If the franchisor elects to reject, is it relieved of its obligation to continue paying the area representative its split of the royalties that's typically provided under these contracts? Can it effectively revoke the area representative's authority, and what type of damage claim might the area representative have if the franchisor rejected that agreement? We don't have good answers to those questions, but those are certainly things that are going to come up in the event that a franchisor is looking at rejecting that type of contract. The other commonly used agreement in franchise systems in the U.S. is a multi-unit development contract. The developer is granted the right to open new units, and it has prepaid fees, generally a portion of the initial franchise fee for the right to open those units. That is probably going to be considered an executory contract under bankruptcy rules because the franchisor has an obligation to issue new franchise agreements and to apply prepaid fees to those initial franchise fees when the developer seeks to open additional units. There's generally not trademark use provided in the multi-unit development agreement. Rather, that's covered in the franchise agreement when it's signed. And so again, as an executory contract, we'd have to look at this in terms of what the impact of the general bankruptcy rules would be on a rejection of that contract. Can the franchisor, for example, effectively revoke the right to open new units by breaching its obligation by way of rejection to issue new franchise agreements to the developer? Would it be able to terminate territorial rights? Would the developer have a claim for prepaid development and franchise fees? So those would be issues that would have to be looked at in terms of analysis of assumption or rejection of a multi-unit development agreement. So that covers my portion of the presentation. Were there any questions? We haven't received audience questions. Sheldon, would you want to pick it up at this point?
Sure. Well, thanks, Jim. Phil, I wondered if you had anything to add before we do go to questions. And let me say to our audience that is the conclusion of our prepared remarks and slides. So if you want to use the next 30 to 60 seconds or so to shoot any questions to us in the portal, please feel free to do that. In the meantime, Phil, I wondered if you had anything to add after Jim's presentation.
Thank you, Sheldon, for the invitation. I don't really in a substantive way. As someone who's been following this bankruptcy analysis of what is the consequence of rejecting a contract, this is really a very important decision that quite frankly brings a fair bit of clarity to the whole debate about the consequences of rejection that simply did not exist previously. And as I mentioned in my remarks, this analysis goes well beyond intellectual property licenses, but certainly it's really, really important in that context.
I couldn't agree with you more, Phil. From the standpoint of a trademark owner or potential licensee of a trademark, there's been such uncertainty for so many years now about what would happen if there was a bankruptcy, that we've gone through a lot of conniptions in trying to draft around these potentials, and depending on trying to figure out if you might end up in the Seventh Circuit or in the Fourth Circuit, or the circuit split was really very well pronounced. So it's great to have this clarity now. And from the standpoint of somebody who usually represents trademark owners, it's great to have this clarity. And I know that our clients are going to be much better served now by this decision, which, by the way, was an 8-1 decision. Justice Gorsuch dissented, but really on technical grounds. He had thought that the case was moot, but otherwise we had pretty good agreement. You don't often get that today from the Supreme Court, but this wasn't really much of a political or liberal versus conservative type of issue, so it was nice to have that strong statement from the court. So
one thing, Sheldon, one thing that probably bears saying is one of the things that this decision does not do, and that's its lack of any impact on a situation where the franchisee or licensee is the debtor. In that instance, the licensee or franchisee, has the option of assuming or rejecting the franchise or license agreement, but this decision doesn't really impact on that. If the franchisee or licensee assumes, then it's going to have to provide adequate assurance that it can continue to perform, and it will maintain its rights, and the franchisor will continue to have its obligations under the franchise agreement. If the franchisee rejects the agreement, on the other hand, then Phil can maybe speak to some of the consequences of that, but it will lose. This decision doesn't protect the franchisee in terms of allowing it to continue to use the trademark if it is the bankruptcy debtor and elects to reject the contract. That's correct, isn't it, Phil?
Yeah, I would concur with your analysis, particularly on the assumption side. On the rejection side, I think that one of the consequences of this rejection as breach analysis will be to strengthen an argument by the non-debtor franchisor that when the franchisee, with the bankruptcy court approval, rejects the franchise agreement, that does not make the post-termination obligations unenforceable. I mean, when the licensee rejects, again, that's a breach by the licensee under the mission product analysis. And outside of bankruptcy, those post-term covenants normally are enforceable, subject to some of the comments you made. And I think by incorporating this analysis, that makes the franchisor's arguments stronger. I went back and took a look at how the decisions on post-termination enforcement against rejected franchise agreements by licensee debtors have developed. And in the 80s and early 90s, those kinds of actions were not very well enforced by the bankruptcy courts. But over the last couple of decades, the bankruptcy courts have become more willing to enforce the post-termination obligations after rejection by a licensee. So this, I think, only adds further support to that development.
Thanks, Phil, and I think that's a point that's probably of interest to our audience, just because I think most people who are listening are involved on the franchisor side and probably are dealing with franchisee bankruptcies from time to time. So even though that's not a focus of our program, it's an important point to raise that even though this decision doesn't maybe directly impact that question of what the franchisee's rights and obligations are, it does clarify that point or add support to that point. And that's certainly something that a franchisor would take into account if it's dealing with a situation where a franchisee has filed bankruptcy.
Correct.
Okay, well, very good. So we must have done a great job here because we haven't received any online questions from our web audience. But I will say that if anyone listening would like to follow up with us on any aspect of this topic, please don't hesitate to contact us offline. And with that, we're ready to sign off. Thank you for listening and have a pleasant afternoon. Bye.